Mrs. Abigail? It appears that we don't have Mrs. Abigail. So I'll go straight into the Q&A box. For Mr. Olomola, I have a question here for you. Sandra wants to know, can the Finance Act be used to amend CAMA 2020? Granted that the Finance Act provision on unclaimed dividends and funds is in favor of owners/beneficiaries, does this not amount to conflict of laws? I'll read out the questions and then you can take notes of them and then we'll answer them at the same time. Olamide Ashade wants to know, shareholders with unclaimed dividends do not have a record of the value of their returns. The UFTF should provide a detailed breakdown of the dividend and interest earned. Otherwise, this would affect stakeholder trust. This is actually a recommendation and not a question. Another question by Tunji Oyeniran is, what is the capacity of the government agency that will manage the fund? What about the issue of inefficiency in government? I'll direct this question to Mrs. Anastasia Brimo. What is the capacity of the government agency that will manage the fund? What about the issue of inefficiency in government? Also, I'd like to, another question by Nkem Agboti is, under the new regime, what motivates companies to make an honest effort to find the shareholders? I would like to direct this to Mrs. Toyin Bashir. And Cynthia Izunobi wants to know, how can she go about reclaiming unclaimed dividends? I'll direct this question to Sunny Nwosu, who is also a shareholder. So finally, I have a question here that says, one hopes the procedure for reclaiming the unclaimed dividends and dormant funds in dormant accounts with the accrued interest will not be too cumbersome. People are often skeptical and wary about bottlenecks involved in obtaining anything from the government. One hopes too many conditions will not be imposed. This is actually a comment from one of our speakers, from one of our attendees. So I'd like to add on, Mr. Olomola, please.
Mr. Moderator, please, let me just add this so that Mr. Olomola can also provide clarification. Mr. Olomola in his paper made reference to Section 72 of the Banks and Other Financial Institutions Act, which the President signed into law in November 2020, and also the Finance Act. You will recall that in Section 60 of the Finance Act 2020, the provision of Section 432 of CAMA on management of dividend and unclaimed dividend was brought into the Finance Act and modified. However, there is no reference in the Finance Act 2020 to any provision of the Banks and Other Financial Institutions Act in such a way as to modify it. And if you look at Section 72 of the Banks and Other Financial Institutions Act, it provides that a bank would transfer unutilized or balances in dormant accounts to a designated account with the CBN after 10 years. Whereas if you look at the Finance Act, it talks about transfer of money in dormant accounts after 6 years to UFTF, not CBN. So we have the BOFIA, which was made in November 2020, directing banks to transfer balances in dormant accounts to the designated account with the CBN after 10 years. And the Finance Act talking about transferring this money to UFTF after 6 years. So we have these two conflicts. Now, can we say that the Finance Act has impliedly amended the BOFIA that was signed into law in November 2020, when that was not expressly made, whereas the modification of CAMA was expressly made in Section 60 of the Finance Act. How will you advise the banks to go about this conflict, since there is no express amendment in the Finance Act of BOFIA regarding Section 72?
All right, thank you so much, Mr. President, and thank you, moderator, Mrs. Agagu, and thank you also to all the other panelists and speakers for your very insightful comments and insights into the Finance Act. I'm very grateful for Sir Nwosu's comments. Like I said, he's someone I have followed for many years. When I qualified as a lawyer some 31 years ago now, I've followed both himself and some of his other colleagues in the shareholder associations, and they have fought the good fight of bringing attention to the affairs of shareholders in the capital markets. I thank you, sir, for your untiring efforts. I'm also grateful that a representative of shareholder associations, two representatives of shareholder associations, will be on the governance board of the UFTF. And I believe that with people like you in that governance committee, you will be able to guide the trust fund in the applicable way to ensure that all your concerns are fully addressed. Thank you very much, sir. In terms of the question as to conflict of laws, as the president, Mr. Ayeku, has rightly said, the Finance Act specifically references the provisions of the Companies and Allied Matters Act and purports to amend and substitute a section in CAMA. By reason of that, I mean, of course, both laws are legislation passed by the National Assembly of Nigeria and endorsed by the president, assented to by the president. So they are equally, they are of equal standing as laws. And when you have such laws where there's an explicit reference to an existing legislation that then amends, it is very clear that the Finance Act has amended CAMA. That is what it says expressly. It doesn't require interpretation. It says, I call into CAMA and I amend CAMA. So there cannot be a question as to whether it's conflicting with CAMA. It has amended CAMA. The very other important question that has been raised was then introduced by Mr. Ayeku, who also then raised the question of BOFIA. If you recall, at the time we were doing the stakeholder consultations and we were all going up to express our opinion on the Finance Act, the BOFIA had not yet been signed into law. It was still a proposal. So BOFIA was signed into law by the president in November, and the Finance Act was signed by the president in December. So fortunately, being later in time, so firstly, the principle of legal interpretation of statutes is that the parliament, the legislature is assumed to be aware of the content of all laws that it has previously passed. So legislature is never ignorant of laws it has already passed. So in passing the Finance Act of 2020, it is assumed that the legislature was aware of what it had passed in November, that the president had assented to in November. Therefore, under the conflict of laws rule, the Finance Act of 2020 ought to prevail over the BOFIA of November 2020, since Finance Act only became effective in December of 2020 with the commencement date of 1st January. However, my own advice would be that these are matters that are best resolved by engaging with the regulators. Thankfully, there's a lot of consistency in both legislation. So the domiciliation of the funds may differ, but the principle that both legislation try to enshrine is consistent, which is the need to take those funds out of the cookie jar and hand it over to the regulator. Whether the regulator is Central Bank of Nigeria or UFTF, that's now a matter of detail. So it tells us that there's consistency in government reasoning, there's consistency in lawmaking. The conflict is now, who do we pay it to? Do we give it to Central Bank? Do we give it to UFTF? Central Bank itself is a member of the Governing Council of UFTF. So I don't believe or expect that there will be a lot of conflict in those two legislation. From a legal perspective, my opinion is that the Finance Act supersedes, but I'm sure all this will be harmonized in due course. So I thank you very much for the opportunity to respond. Oyin, you are still muted, Oyin.
My apologies. Mrs. Bashir, under the new regime, what motivates companies to make an honest effort to find shareholders?
Okay, yes, thank you. I believe this question was from Nkem in my opinion, and I suspect that she means that in terms of financial incentives, given that the previous regime, there was some interest in, the company receiving, monies after its prescribed period, and then the fact that it just looks like they're just warehousing money for, government to move it into the fund. Personally, I think that this is really up to the regulators. Public companies work in the space of, a regulated space. You have the SEC, you have the CIBN, and then you have, various other regulators depending on the industry. And so it's really up to them to basically delve a bit deeper and, come up with rules, policies, whatever that can support such moves. And it's not a new initiative in the sense that, of course, we've said the fact that it's being done in other jurisdictions. But so there are lessons that can be borrowed from those jurisdictions in coming up with some kind of policies that can support such moves.
Mrs. Bashir. Thank you for your contribution. I have another question here that I'd like to read. It is from Mrs. Cecilia Madueke. It says the Finance Act 2020 is laudable in some of its provisions, no doubt. However, it should be noted that shareholding is a contract between the company and the shareholder, and all terms are well understood. Please note that being a listed company is about the marketplace, not about the contractual relationship. Note also that banking is a contract as well. Unclaimed dividend is a problem between contractual parties, exacerbated by the structures that proved inadequate, especially banking and estate frameworks. So she mentions that should government overreach to intervene in a contractual process where both parties have not brought these matters to the government agencies, especially the judiciary? She also mentions, would this not give the impression to the investing public and international investors that governments can interject itself into private contractual relations? Finally, she says, should the government criminalize an understood contractual agreements? I'll leave these thoughts with you as a final question also goes to Mr. Olomola. The Crisis Intervention Fund is a short-term fund created for a time. The fund is a sub-fund, the UDF fund is a sub-fund of that fund. She wants to know, will these two funds co-terminate? Mr. Olomola, if you would please.
Thank you very much. My understanding is that the funds will not co-terminate because the Crisis Intervention Fund is a standalone fund that addresses certain matters, while the UFTF is a perpetual fund that's managed by a different body, in this case, the Governing Council under the Secretariat of the DMO. So it's just for convenience that it has been grouped as a sub-fund. But to all intents and purposes, it stands alone with its own separate governance, which is the DMO, as supervised by the Governing Council. I would like to spare a moment to talk about the status of contracts and to remind everyone that, under the contracts, under the law that's applicable to contracts, you have a 6-year limitation rule. And so governments have always been able to intervene in the area of private contracts. There are laws that regulate private contracts, the sanctity of contracts, the enforcement of contracts and the like, and the termination of contractual rights. The question that then happens, remember, we're not dealing with active accounts or active dividends. We're dealing with situations where you have not exercised your contractual right or your right to payment for a period in excess of 6 years. As the law stands today, typically your contract cannot be enforced after 6 years, or in the case of dividends, after 12 years. So bear that in mind. So government does have the ability to pass laws, and have demonstrated that this same approach has been done in other countries in relation to personal property, which includes money, rights, securities, and so on and so forth. Thank you very much.
Thank you, Mr. Olomola. Finally, Cynthia wants to know how to go about reclaiming unclaimed dividends. Sir Sunny Nwosu, could you kindly respond to that?
Okay, one, she have to recognize all the registrars under which her shares relate to. After doing that, she'll go to the registrars. They'll give her a form to fill. That form will enable the registrar to look into their books and find out whether she has unclaimed dividend or not. And after that, she will get her bank to give her what they call a letter of confirmation of her signature. And as soon as that is done, they will transfer the money to her account. But that is also part of the problems we're having, because the banks continue to ask for a fee for that. And that has enabled people to go to the bank for so many of these things. But if you continue to have any problem about it, you can pass my telephone number to her. I will help her to show her the way to get her unclaimed dividend. Thank you.
Thank you very much, Sir Sunny Nwosu.
In addition to that, the moderator, before the chairman comes in addition to what Sir Sunny Nwosu said, it's also very simple. SEC has made life easy for everybody. There is a link that this particular shareholder can just access through SEC. We also post it on the platform. Immediately she types her name, all the company where he or she has unclaimed dividend will pop up, so that she can then know exactly the registrars to visit, and then just start the process. So wherever you are in any part of the world, using that link that the SEC has developed, you can just know the companies where you have unclaimed dividend, and then you can see the registrar managing. You can also get the form, download the form online, fill, and then you can take it up with the registrar. But we also make that link available. It will be part of what will be sent to all participants in this program. Thank you.